My name is Denise Evans with Butler Evans Real Estate. We are commercial and investment real estate brokers in Alabama. This video is about Alabama real estate wholesaling law and the 2023 statute that imposes duties on wholesalers. Well, who does this apply to? Alabama Code Sections 842.1 through 842.3 applies to someone who acquires an interest in a single-family residential property as the buyer under a purchase contract and then assigns or offers to assign the interest for a fee to a third party. What does it apply to? It applies to transfers of equitable interest in a single-family residence, whether by assignment, novation, or other similar method of transferring interest in real estate. When you sign a real estate contract to buy property from me, you now have what is called an equitable interest in my real estate because of that contract. It is the thing that allows you to put insurance on property you're buying from me, even though you do not yet own it. When does this come into play? A wholesaler must disclose in writing to any potential subsequent purchaser the nature of the buyer's interest. Any potential subsequent purchaser means you've got to include that in all of your marketing, that you're marketing a contract, not real estate. And to the seller, before doing any marketing, you have to disclose the wholesaler's intent to market its interest, and to the seller at least 3 business days prior to the effective date of any assignment, the effective date of any assignment of the wholesaler's interest. Is a double closing included? That's where A deeds to B and then B deeds to C in a double closing. What if you don't assign your contract, but you go through with closing and then immediately have a second closing to your own purchaser? In my opinion, you are still obligated to make the disclosures because you're trying to sell something you do not yet own. Remember, the disclosures are to potential buyers. Failure to abide by the rules have penalties of a Class C misdemeanor with jail time up to 90 days and fines up to $500. In addition, the person who was owed the disclosure may sue for an amount equal to 3 times the fee or amount received by the wholesaler on the transaction. In other words, triple damages. I received questions about real estate licenses for wholesaling. You must have a real estate license to market property you do not own. To avoid this problem, you must be clear you are marketing a purchase contract, not the real estate itself. Well, thank you for watching this video. I hope it cleared up some misconceptions for you. If you like this, please subscribe to my channel. A review would be welcome. And also visit my website at www.butlerevansrealestate.com for my real estate listings and other real estate materials and the educational materials I have for Alabama real estate investors.